Hello. I know you all can hear me because we're working. Meow away wolf. Good to see you this past weekend. So good to see you. Thank you for showing up. Mama Malicious. Good to see you. Fire Flame. Thank you for tuning in. We're going to give a couple of more people an opportunity to log on. Hi, Barbara. Oh, wow. That number jumped. It went from 17 to 34 to 45. I guess we have some excited. Oh, now we're at 51. We have some people that are excited about today. Kojak, thank you for tuning in. I can't wait for today either because this will be an excellent series covering the enforcement hearing. Okay. Michelle, Melinda, how y'all doing? Laquan, Don, hello. Is it Jerkeem from Dallas? Good to see you. Lois, hello there. Crazy in Love 466 from Ontario, Canada. Jacoby from Indiana. Deborah from North Carolina. Hi, Bruce. Dee Dee from Florida. How's it going? Ron, living with, is it Naya or Nia? Either way, thank you for being here. Yvonne from Houston. Hi, Darius. Hi, Marcy. Queen Bianca, how are y'all doing? We are now at 69 people. Ashley, Paparazzi, Kiki, um, Camilla, OMG, I love your show. You encourage me to pursue law. Thank you so much. Meow Away Wolf showing support by liking the video. Thank you so much. I would to make sure that they are subscribed to our channel, they are liking the information, and they are sharing it. Because remember, this is limited to Texas law, right? Because that's where I'm licensed, that's the law that I know. But if you hear anything that I may say, it may be applicable to the state that you're in. You just need to consult with an attorney in your jurisdiction, okay? So we're going to go ahead and get started. Hi, Adam. Hi, Forest Strings. Beaumont, Texas. Okay, I love it. All right, so we're going to go ahead and hop in, you guys. All right, so I told you all last week that we were going to be covering the enforcement hearing. What is an enforcement hearing in Texas? Okay. Oh my gosh, hi from Egypt. I always watch your videos and like your information flow. Thank you so much. I love you guys for supporting me like you do and being from all over. Okay, I love it. All right, so what is an enforcement action? Make sure you all have your pen and paper ready. All right. The enforcement action, when you bring about an enforcement action, you are essentially telling the court and or the judge, right, that the other person has violated some portion of the court order. Okay. So it can be any provision of the court order. It can be a temporary order. It can be a final order. Any provision contained within the temporary order or the final order, you are telling the judge this other person has violated this order. Okay. That's essentially what an enforcement is in Texas. Someone has violated the order. You want to put the court on notice that they did it, right? Like I said, it can be any provision of the order. It can be a temporary order or it can be a final order. All right. Now, for purposes of what we will be discussing, I'm going to narrow those enforcement actions to only child support and possession and access. Well, you may ask, Vonda, why are you only limiting the discussion to child support and possession and access? Great question. The reason I am doing it is because based on you all's feedback on my videos on here, on YouTube, on TikTok, as well as Instagram, and even on Facebook, the majority of the violations are coming from either the failure to pay child support or the failure to follow the court orders possession and access schedule. Okay, so that's the reason why I'm limiting those two. I hope you all caught that. So just a brief recap: someone has violated a provision of the order. Can be a temporary order, can be a final order. All right, child support, possession and access, those are our scopes. All right, let's go into it. So before you can even get to court, right? Someone has violated your rights under this court order. Before you can even get to court, remember, you have to put your allegations in a motion. A motion you will always hear it referred to as a pleading. It's the same thing, okay? A motion is a pleading, all right? In the pleading, in the motion, you must tell the judge what the person did in an enforcement action. Okay, this is your first time speaking to the court to let them know how the order has been violated. So it is important, you guys, make sure if you are taking notes and you have pen and paper, put an asterisk by this part. Okay, you have to make sure that your motion is on point. What will happen if I am missing something in my motion? You will not get the relief that you're seeking. What do you mean by that? That means that you're asking for somebody to go to jail. It's not going to happen if your motion is not correct. So that's why we're going to have this introduction about what a motion needs to contain. The first thing I want to do is to direct you all's attention. Make sure you write this down. For those of you who are going to be representing yourself, or at some point, if you decide that you want to hire an attorney, you at least want to know what section that I'm reading from in the family code. Okay. We are covering section 157.001 of the Texas Family Code. Again, that is chapter 157.001 of the Texas Family Code. That is discussing the motion for enforcement. Okay. Now, I'm getting ready to go on to the contents of a motion for enforcement. What certain things must is not an option, guys. It's not a may, it's not a can. Okay. It is a must, which means that you know contents of the motion for enforcement. That is section 157.002. All motions for enforcement must include these things. All right. You have to identify the provisions of the order. So, what certain areas of the order have been violated by the other person? All right. You then must state the manner in which the violation occurred. And I know you all, this may be going over your head. So it's like, what does this actually mean? Trust me, I'm going to break it down. Y'all know how I do. I'm going to break it down so you can understand it. I just at least want to read you what the code says first. The next thing you must do, you must state the relief requested. What are you asking the court to do? And then you must sign the motion. So at the bottom of a motion, or at the end of a motion, when you're finished with all of your requests, it'll have respectfully submitted or something to that nature, who the person is that actually did the motion, right? That is you. If you hire an attorney, that's your attorney. You have to sign it, guys. And by signing it, you don't actually have to print it out and put your John Hancock on it, right? Your signature can be electronic, and you can write your name. So for example, Jane Doe, you know how you do the little slash that I don't know the proper term for it, but it looks like this, the little slash, and then you put an S and then put another slash. So that's pretty much saying this was signed by you. It's simple. You don't have to do anything out of the ordinary, anything extra. Very, very simple to do. Okay. So, what did all of that mean that I just told you? And y'all have to excuse me, I'm going to remove these glasses. If you all caught my video that I placed on TikTok and Instagram today, I took Christmas pictures today with my family. So I have these eyelashes on and they are bothering me. I'm not just quite used to them yet. So, what does all of that mean about the contents of a motion for enforcement? Let me break it down. Very simple. You all may remember this from grade school. Who, what, when, where, why. That's it. Your meaning, who is the person that you are referring to that violated the order? What did they do? When did they do it? Or when did they fail to do it? Where did it happen according to the order? And how did they violate? It's that simple, guys. Very, very simple. Who, what, when, where, how. That's what you're doing. Let me make sure that I'm being very clear though. When I say who, what, when, where, and how, you actually have to tell the judge that. You can't just put petitioner did this, respondent did this, and the child, this is what happened. No, you have to name the person. Jane Doe violated John Doe's rights by doing what? Da 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 da. Right? When? On Wednesday, November the 24th, 2021. Where? At the Shell gas station located at um the Shell gas station located at 2929 Illinois Drive, right? At 6:00 p.m. Jane Doe failed to arrive and surrender the child. Y'all see where I'm going with that? And when I say the child, comma, little bitty Joe, right? Because they're Jane and John. So little bitty Joe. Name them, name the location, name the name how it took place. Okay. You have to do this, guys. If you do not do this in your motion, it is a fatal error. And guess what? Your case will more than likely get dismissed if the other person says that you fail to track the language of the order. Ooh, there goes some buzzwords. Tracking the language of the order. What does that even mean? So you have your order, right? Your court order. You're trying to say that the other person violated certain provisions of that court order. Literally track the language. If the order says it is ordered that Jane Doe shall surrender the child to John Doe at 29 Shell gas station on 6 p.m. this day, this day, this day. That's all you do on your violations. It's not hard. Is it tedious? Absolutely. Right? Extremely tedious. Even for me, when I'm drafting it for my clients, it is extremely tedious. Any slight misstep can get it thrown out. I will never forget, guys. I had an enforcement action where I was defending dad. Mom was bringing all these allegations against dad, right? Dad's attorney put 6 a.m. instead of 6 p.m. The order says 6 p.m. I got that allegation thrown out. Opposing counsel was confused. Like, wait a minute. We know what time. No, it's a fatal error. Something that small, right? It is fatal. If you do not identify who the person is that you're talking about, that is fatal. If you do not put the location where the alleged violation took place, it is fatal. If you do not put the time, it is fatal. If you do not talk about how the alleged allegation took place, alleged violation, took place, it is fatal. Okay. So I am making sure that I want to stress this enough, you guys. It is fatal if your motion does not contain the things that I'm telling you it needs to contain. Okay. So let's move on from there. Now, remember I said we're going to limit our scope to child support and possession and access. Well, let's talk about the child support motion. All right. Remember, I told you what needs to be in all enforcement motions: who, what, when, where, why, and how. Okay. Motions for child support in particular. Okay. You have to do a little bit more with these motions. Let me just say, if you are receiving child support and it goes through the Texas Attorney General's office, you must send a copy of your motion to the Texas Attorney General. You must do it. They are what is called a necessary party. You may also hear of them referred to as an interested party. Okay, that means they have an interest in that particular case. That means they are necessary to the hearing and they have the right to be on notice of what is going on in that hearing. Okay, so you notice I said you must send them a copy of it. You may hear that as you must serve them. It means the same thing. Serve, receive a copy. That means they have to be on notice of the motion. Okay, and I'm going to tell you why that is important that they be served. Okay, in the child support motion, all right, you're alleging that someone has failed to follow the provisions of being ordered to pay child support, right? So you have to show these things in your motion. You have to show how much money they were supposed to pay. So how much is owed, the amount owed. All you have to do is go to your child support order, see what the amount owed was. Hypothetically speaking, in the order it said that Jane Doe, John Doe were ordered to pay $300 per month on every first day of each month, right? So in your motion, you're going to tell the court that it's $300 owed per month, all right? If you are requesting contempt, any sort of contempt, remember, contempt comes in two forms. It could either be by criminal contempt, which is where you're asking the court to put that person in jail, and or civil contempt, where you're asking that they be responsible for the court fines, court costs, as well as attorney's fees if you hire an attorney. If you're going to be requesting contempt, you have to show the alleged violation, like what provision of order did they violate, the date that they were supposed to follow what stated in the order. So the date of payment, remember, the amount that's due, and the amount that is paid. All right. So let me break that down for you. Jane Doe, John Doe failed to pay child support. That's the alleged violation, right? It was due on the first of each month. Don't write that in your order. Don't write that in your motion. Your order says that it was due on the first month the first day of each month. So in your motion, write out the date: November 1st, 2021, December 1st, 2021. You see what I'm saying? Write out the date. It's telling you it's on the first of every month. So write out the date. You already know what it is. The amount due, $300. The amount paid, $0 or $10 or $30, however much was paid, if any, you put that in there. Okay. The easiest way to show the court that specific information I just gave you is to make a chart. So if you go on Microsoft Word, or if you go in Excel, any one of you that are good with doing charts and such, just put a chart in there and start from left to right. Failed to pay child support. This is the amount that was due. This was the amount paid. The easiest way to show the judge what the violation is. Okay. Now, before I move on to the next one, you want to make sure that the language out of the order that you're asking the court to enforce because someone violated it. You have to literally put that language in your motion. So remember, I just told you if you're requesting contempt, you have to have alleged violation, the date, amount due, amount paid, right? Above that, you have to tell the court what the order says. What is the language? It is ordered that blah, 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 blah on page 19 of the order. Write it out. Matter of fact, you don't even have to physically write it. You know what you can do? Copy and paste. Take your order, highlight it with the portions that you're going to be talking about in your violation, your allegation, right? Copy it and put it above that chart that I'm telling you about. Boom, you're done. You don't have to do anything more. From there, you just track the language in your chart. All right. Remember when I told you all you have to serve or put the attorney general on notice. The reason I told you that is because if you're trying to say someone failed to pay child support, the attorney general has the official payment record to show what has been paid and what has not been paid. Okay. The payment record will say the person's name. So at the top of it, it'll have your case number. It'll have CP, which means custodial parent. It'll have that person's name to it right after it. It'll have NCP, then that person's name. Then it will just show you the dates that child support was ordered, the dates that it was actually collected, and what is still outstanding, what is still due. So remember that chart I told you about? The payment record is just another way to double check your work. If you're saying they violated on these days, look at the payment record, compare your payment record to the motion, match it up, you're good, right? But the attorney general is usually the person that brings the payment record to the court. Now, you may attach a copy of the payment record to your official motion, right? You may do that. In terms of doing things the right way, though, you not only want to attach it, you want to make sure that you use it as an exhibit, and we'll get into exhibits later regarding this hearing. But you also want to make sure that the attorney general is present. The attorney general has an interest in the case. They want to ask the other side questions. So it kind of gives you some relief, right? You definitely have to prove up your case to show that they failed to pay on these dates. But the attorney general is essentially doing the same thing because they're a necessary party, right? So make sure that you have a copy of the payment record and you have served the attorney general on for your hearing. Okay. All right. Now, in talking about child support a little bit more, just make sure you understand that the person who is getting served with the child support motion, they do have some defenses, right? So let's use an example like we've been talking about Jane Doe and John Doe. Jane files an enforcement motion against John for failing to pay child support. Jane gets John properly served with the citation. Okay, the citation is letting him know that he's been sued for something, right? He's also being served with the show cause, which is also referred as an order to appear. That is the order that has the judge's signature attached to it, and it's pretty much commanding John to appear in court on this day at this time. Okay, you have to have both of those. If you do not serve someone with an order to appear and you only do the citation, and you set that for a hearing, guess what? They don't have to show up to the hearing. Okay. You have to serve them with both citation, order to appear. Okay. After you serve John Doe is the respondent. So the person in an enforcement, and you'll hear different language. You typically will hear petitioner and respondent in cases involving child support, right? But in the case of an enforcement, the person bringing the enforcement is referred to as a movant. The person answering the motion for enforcement is the respondent, the responding party. Okay. So John Doe is the respondent. John Doe has a right to file defenses to your motion. What do I mean by that? John is saying, I didn't have no money to pay you child support. I lost my job. I'm incapable of working because I am disabled or whatever the case may be. He has the right to verify all of those defenses. Now, what do I mean by verify? There's another buzzword, right? Verify. Whenever you hear the word verify or you hear a verification pleading, something like that, that simply means that you have to get that document notarized. Okay. Verify, verification, notary. Just make sure you remember that. All right. So you have to have affirmative defenses notarized. If you want them to be a verification, right? They have to be notarized. To be on the safe side, when it comes to an enforcement where jail time is on the table, I just say err on the side of caution and get it notarized. Okay. So again, you have the respondent does have some defenses. And I want to make sure that you all have the code section for that. So remember, I told you the enforcement section itself is 157 of the Texas Family Code. So make sure you all are going through that to see about what it is I'm walking you through. All right. So you have these defenses. John Doe is saying, this is why, this is why, this is why. Will those defenses necessarily fly? It depends. It really depends on what the case law says. So all of these laws and everything like that, these rules of law that I'm giving you all, it stems from a case that has taken place in Texas, right? It really depends on what defenses you are bringing. Let me just go ahead and put this out there to say, I have the money, I lost my job, I just didn't pay it. That is not going to fly. Okay. That is not going to fly. It literally has to be a situation where you're completely indigent. And what do I mean by indigent? You have no money. You are someone who is more than likely transient, where you're living on the streets, you're homeless, you don't have the means to borrow it from a family member or anything like that. You have no car, no home, no assets, nothing, right? You don't have not a cent to your name. In those cases, it may be hard to hold that type of person in contempt with that verified defense. Okay. But if you're someone who is willing and able-bodied, you don't have any ailments or anything like that that would hinder you from working, you have family members that you can borrow money from. You're saying you don't have the money, but you go out and buy a new Benz or a new Porsche, or you buy your spouse a new ring. You all take a lavish vacation. Um, those types of things. Your kids are in private school. The judge is not going to believe that you're indigent. So that defense is not going to fly. Okay. And be very careful too. I want to make sure I caution you all. Be very careful in your pleadings in terms of filing a defense about saying that you're indigent. Be very careful about that. I will never forget, I saw a court hearing where an attorney had an enforcement brought against them for failing to pay child support. And the attorney tried to allege that they were indigent. That is not going to fly. It's not going to fly not only because it's more than likely not true, but remember, you're an attorney. You are a licensed member of the State Bar of Texas, which means you can be disciplined if you lie in a pleading like that. So be very careful. That happened to an attorney. I don't know if they got disciplined or anything, but the judge definitely cautioned the attorney about bringing up that defense. So any of you who have professional licenses, be careful in these verified pleadings, because what did I say about a verified pleading? It is notarized. So when you are signing something in the presence of a notary, you are verifying that everything in that document is true. Don't verify anything if you're going to lie. Don't file anything in court if you're going to lie, but definitely don't verify it. Okay? That's just dumb. Don't do that. Again, protect your professional licenses and do not lie in court. It's just not going to be a good look, and it could affect you beyond that court hearing in terms of the licensing board that you may have to be in front of one day. So don't do that. Okay? Now, beyond the defenses, we talked about the defenses that John Doe has. What if John Doe is properly served and he fails to show up for court? What do you guys think is going to happen? 9 times out of 10, the court has a couple of options, right? The court can not only proceed with the hearing, which means they will enter a default, but a Kpis warrant could also be issued on the respondent. What is a Kpis warrant? That is a warrant where you are saying to the sheriff or the constable or any police official within your jurisdiction to bring that person to court. All right? Don't do that. Because if a Kpis is issued on you, guess what? They can pick you up anyway. You can be if it's not on a Sunday, you can be in church. You can be at your new boo house. Don't do that. Like I've seen it all. And I'm not saying, I'm just telling y'all the things that I have seen in some of the places that you would never think they would get caught up in. If you are served, just show up. Okay. Now, what if you are served on Monday and the hearing is on that following Thursday or Friday? Do you still need to show up to court? You absolutely need to still show up to court. Okay. Now, the thing is, when you show up, because it's less than 10 days on an enforcement hearing, if you're serving someone, they have the right to have at least 10 days before the hearing, right? So if you're serving them within the same week that the hearing is taking place, they have the right to ask the judge for a reset to give them the opportunity to hire an attorney. Well, what does that look like? The judge may give you 30 days. Depending on the judge's calendar, it could be more than 30 days, right? You see, the person that's the movement that filed that could be a delay for them. So just try to do things the right way. Even if they have more than 10 days, they're still going to have the right to ask for a reset if they don't have an attorney. If they show up to the hearing and they don't have an attorney, before the hearing takes place, the judge must have what's called a rights hearing. What is a rights hearing, Vonda? A rights hearing is a hearing, it's a mini hearing before the enforcement hearing begins, usually no longer than 3 or 4 questions, literally total, where the judge will ask the person, are they employed? Where they're employed, how much money they make, how many hours they work, all that kind of stuff. It's to determine if they're indigent. Because if a person is indigent and they're ordered to pay child support, the court can appoint them an attorney through the public defender's office, right? Now, if that person is determined not to be indigent based on those questions, you can either choose to move forward with the hearing and represent yourself, or you can ask the court for a reset so you can go hire you an attorney. If you can hire an attorney, I always believe that someone should have an attorney representing them at an enforcement hearing. Why is that? Because your civil liberties are in jeopardy. If contempt is requested, jail time is on the table. You're going to jail. Okay? You are going to jail. And let me dispel this rumor, because people think that mothers do not go to jail. That is so far from the truth. I can tell you. I was watching a court on Zoom the other day. They were on Zoom. It's streamed on YouTube. Mother was violating the order, not letting dad see the child, right? Guess what the judge did? The judge gave her a date to come back after Thanksgiving to turn herself in, and serve her jail sentence. And she has to stay in jail until she pays that fine and the attorney's fees that are ordered. Okay? Don't do that to yourself. Don't think for 1 second that mothers do not go to jail. Mothers go to jail all the time. All right? So that brings us to a stopping point in terms of the information we're going to cover today. Now, let's do a brief recap before I get into you all's questions. I see the chat blowing up over there. Remember, what is an enforcement action? You are bringing that action to court to tell the court that the other person has violated some provision of the order. All right. Remember, the order can be temporary or it can be final. In terms of what we're discussing, we're narrowing the provisions to child support and possession and access. Okay. All motions on an enforcement. Remember who, what, when, where, why, and how. If you remember that, you cannot go wrong. For terms of clarification, if you feel like you need a little bit more explanation on that, make sure that you are going to specifically what the contents of an enforcement motion must include. All right. We're talking about child support motions now. Child support motions. Remember, you must show the amount owed. If you are requesting contempt, whether it's criminal contempt, civil contempt, you must show the order with the alleged violations, the date, the amount due, the amount paid, attach a copy of the payment record from the Attorney General, serve the Attorney General so they can show up and participate in the hearing. Remember, necessary party. Okay. All right. So I hope I hope I answered you all's questions in regards to what the enforcement was, just giving you an introduction to that. Again, Section 157 covers the enforcement. So that's what we're going to be talking about for the next couple of live sessions. Okay. We may be on here. The temporary orders hearing sessions were about 4 parts. The enforcement hearing, it may be about 5 or 6 parts because it is a lot. The next time we're going to talk about possession and access. Okay. So let's get into the questions. So Vonda, you said it costs $50K to file a TRO. So women actually spend $50K to falsely file a TRO. I don't remember saying $50K initially. But you can easily pay $50K depending on the circumstances. But to answer your question about this question in particular, yes, I have seen women fraudulently file a lot of things in court and spend the money to do it. I have seen it happen. Are you ever going to have a court show on TV? I would love to see you on TV. Carol, actually, someone reached out to me just yesterday about syndicating the show. I don't know. You'll have to stay tuned and we'll see how it goes. But thank you. Why are they saying you're going to jail? Someone lying. Love your educational and let us know the law. Thank you for all you do. You're very welcome. You're very welcome. I love your videos. What is the limit of no payment of money you can go to jail? Laquan, this is a great question. There isn't a limit. If you are found to be in contempt, if you are found to be where you have violated any provision of the court order, specifically your question is dealing with child support. If you have not paid the amount in child support you're supposed to pay, you are at risk of going to jail, period. It doesn't matter the amount. Great question, Juan. Hi, Fallon from Louisiana. Little bitty Joe. Okay, Fire Flame. What if you followed the language and the judge overlooks all the information that has been provided? Fire Flame, this is a great question. It really, really depends, right? Before the judge can even entertain any evidence that you have, they must first look at your motion. If your motion is flawed, if it's missing something, that could be a reason why a judge would overlook any information that you have. And 9 times out of 10, if it's requested, they're going to dismiss your case. So that's why it's very important that you spend time specifically crafting your motion. You have to have your motion on point. Otherwise, you're going to lose that case. How long does it have to be before you can enforce child support or hold them in contempt? Great question, Fallon. You can do it right away. I always say, give the person an opportunity, right? Yes, they had an opportunity when the court order was put in place. However, especially during COVID, you all have seen what happened. People have lost their jobs in terms of termination, layoffs, reduction in hours. Try to talk to the other parent and see what's going on. Give them an opportunity to remedy the situation. I always say do that before you file any enforcement action. That's assuming you and the other parent have a good co-parenting relationship. If it's a deadbeat parent that doesn't have anything to do with the child or anything like that, then have your way and file your motion whenever you deem it necessary. Okay. Um, let's see. What if the attorney general never shows up? Fireflame, that is an excellent question. You can't control whether or not they show up. All right. The only thing you are responsible for is to make sure you can show the court they were on notice. What I do when I send notice to the attorney general, I put it on the letterhead. It has the email address associated with it, which is a generic email address. It depends on your region. So normally the attorney general's office is depending on where you're at, whether you're in Dallas County, Denton County, all that kind of stuff, right? They typically come out of one office and they go to these different, I guess you can look at it like different satellite locations located throughout the county. But if you send it to that generic one, you're good. You send it to that generic one, and it literally is very simple. Please find enclosed the motion for enforcement. The hearing has been set on November the 26th, 2021 at 9 o'clock a.m. in the 123 District, 123rd District Court in Dallas County. Put the judge's name, Judge Looney Tunes presiding, right? By receipt of this letter, you are hereby served with notice. Boom. You file that with the court. They're on notice, whether they show up or not. Only thing you are responsible for is to make sure you can prove to the judge that you actually sent them notice. Okay. I feel like if your child non-custodial parent doesn't pay child support, you just got to chalk that up. Don't send them to jail. LOL. How's that going to make your child feel? I wouldn't necessarily say you have to chalk it up. I don't disagree, but also I don't necessarily 100% agree, because for some people it does take for them to be threatened with jail time for them to get it together. Okay. So you don't want to just chalk it up. And just like you don't want your child to see the other parent go to jail, your child shouldn't go without, because the other parent is not handling their obligation under the order either. It's not fair either way you cut it. So if you want someone to follow the court order, this is the step you more than likely will have to take. Oh, the lead attorney. Salute Judge Vonda. Man, you all have to follow the lead attorney. He has a YouTube channel. Make sure you all tune into him. It's a good guy there. He is out of Atlanta, Georgia, I believe. So those of you who are in Georgia, the lead attorney is an attorney out there, and I believe he practices family law too. So you need help, reach out to the brother. That's a good brother right there. Fire Flame, true. What would be the solution to sending the non-custodial parent to jail? Now you put the parent behind even more and they're not able to pay. True, both parents should pay. Now, let me tell you what I have noticed. People that have been in arrears, they owe back child support, right? They're behind in child support. 10, 15, $20,000. You will be surprised how quick they come up with money when they are threatened with jail time. You will be super surprised. I have seen it happen. I have physically walked checks to the attorney general's office from my clients because they did not want to go to jail. A lot of people think it's a game. You really think it's a game until you're threatened with your civil liberties being stripped away from you. Don't be in that situation. Trust me, they'll come up with the money if they have it, or if they have it from somewhere they can go borrow it from, right? All right. How long are you to borrow for a family member or friend to pay child support? That is a great question. There is not a time limit. So in the court order, it doesn't tell a person you are ordered or it is you shall get money from a friend or a family member, right? That's just a defense that you have if you can't borrow it. But if you need to get the money from somewhere, there that's your alternative, right? And it shouldn't be for a forever thing unless you have a family member that just have long money like that and they just gonna keep paying your responsibility, right? But it should be something that's temporary. Shouldn't be something that takes forever to do. Joe Reed, are you married? Yes, I am married. Next month, actually, my husband and I will be married 3 years. And so yes, I am married. Ruben, I appreciate you too. Thank you. Fireflame, what are you going to do if what are you going to do if you are in contempt because of the attorney not filing the correct information? So that is an excellent question, Fireflame, and we will get to the enforcement order later. But if the attorney didn't file what needed to be filed appropriately in the motion for enforcement, the judge cannot hold them in contempt. If your motion is flawed, that person cannot be held in contempt. So on child support, if you're asking that someone is placed in jail, but you didn't specifically request that they're placed in jail, or you didn't follow each one of those steps to hold them in contempt, the most the judge can do is put a money judgment on them saying that they owe this amount of money and they need to pay it out monthly by at this amount, right? That's it. You can't hold them in contempt by jail. All right. So, very good question. I wish you would have been the judge I dealt with in support court instead of who I got, Monica Moorhead. It and it's not to bash judges or anything like that. I just think it really depends on the individual. I can say from what I have seen practicing law for the past 8 years, not all judges follow the law. Not all of them do what they're supposed to do. They act very irrational, emotional. So that's the unfortunate part of it. That's a lot of times people do get caught up in the personal feelings or the biases of the judge, which I think is so unfortunate. If non-custodial parent is sent to jail, hold on, I missed that question. I think it was by Meow Away Wolf. It was, if non-custodial parent is sent to jail, the outstanding balance of back child support is relieved or it still needs to be paid. That's an excellent question. It still needs to be paid. It does not go away. What if they don't want to get a job but are fully capable of working? Fallon, they can go to jail. It's really that simple. Fully capable of working, don't want to work, you can still be held in contempt and still go to jail. What amount of them being behind chooses not to pay child support or medical reimbursement over $5,000 behind on each of these for a total of 10,000 is needed for criminal and or civil contempt? Yvonne, I believe you may have tuned in to us a little later, but thank you for your question. It doesn't have to be a specific amount. If they're in violation, they're in violation, and you can file your enforcement action. Fallon, but the non-custodial parent also has money for drugs but won't get a job. Now that is part of, if they try to file a defense of indigency, that's going to be a part of your evidence that you're showing that they can afford to pay child support. They have the money to buy drugs. So there you have it. So we'll get into the actual hearing a little bit more as we go into the series a little deeper. But thank you for your question. Clarence, joint custody, do you still have to pay child support? Absolutely. Joint custody does not make anyone exempt from paying child support. Yvonne, he has a job but lives with his parents, doesn't pay rent or utilities, buys expensive jewelry for girlfriend, goes out to eat at expensive restaurants, but refuses to pay child support. Again, that's going to be some of the things that you ask on if that person chooses to testify, right? That's going to be part of your evidence to show that they have the means to pay child support. Meow Away Wolf, opposing counsel sent a motion for withdrawal of counsel. Non-custodial parent failed to respond to their attorney. How can custodial parent use this information, especially when non-custodial parent has supervised visitation and has back child support? A motion to withdraw doesn't have any bearing on the case itself in terms of what the outcome would be as far as the non-custodial parent failing to do something. It's irrelevant to the back child support or child support issue. Yvonne, where can we buy your tune in? Tune in. Coming soon. I will be dropping the nuggets, the t-shirts, the little sweatshirts, the hoodies, the mug, all of that kind of stuff. You'll see it. It's coming soon your way. I will definitely let you all know. My baby daddy signed his parenting rights, but still comes around. Is there anything I can do? I'm assuming you mean he signed them away. Um, at that point, the only thing that I could say that you could do is maybe call the police for trespassing, because if they've signed their rights away, they're legally not a parent anymore. That's the only thing I could think of. Um, M. Ortiz, father dodged Texas Attorney General a few years ago, but now is pursuing a SAPSTR. Remember, I told you SAPCR stands for suit affecting the parent-child relationship. Temporary orders hearing is now scheduled. Once the child support is established, will the AG pursue retroactive child support? This is an excellent question. Or M. Ortiz, if you go back and look at our temporary orders hearings series, that'll kind of give you some insight. But retroactive child support is a final trial issue, not a temporary order. So no judgments will be placed for retroactive child support at the temporary orders hearing. What happens when a woman files for child support modification and doesn't show up? Can I sue her for my attorney and expenses and or travel for cost of 3 hours? You absolutely can. You can ask the court to proceed with the hearing, do what's called a default, meaning that you appeared, they didn't, you incurred expenses. You definitely have to prove those up. We will get into what you would need to do that on a for a modification later on when we cover the modifications. But the simple answer is yes, you can ask for those fees and expenses to be paid for. My baby daddy signed over his rights. He comes around sometimes, but I'm a young mom and needs help. If there's anything, I can take him to court to get help. Now, Miss Correa, I hope I'm saying your name correctly. If the dad has signed over his rights, you cannot take him to court to get any type of child support or any type of benefits. His rights have been terminated. Clarence, thank you so much. Great show. Thank you. Child support modification. You have other children. Do they consider the other children? Absolutely. Having multiple children after your order has been entered is a reason to go and request a modification. If a parent who owes child support dies and the estate is probated, have you seen life insurance proceeds and property liquidated to satisfy any unpaid child support? This is from Jonathan Hawkins. That is an excellent question. The short answer to that is no, because life insurance proceeds typically go by, it's a contract between the person and the insurance company, right? So the contract will be between whoever is in privity to it, right? Now, property liquidation, I can't necessarily say I've seen that, but if it's being probated and there are proceeds there, any child support arrearage, I can imagine it could be satisfied by the liquidation of property. I'm not exactly sure though. I personally have not had any experience with that. What part of the family code in Texas refers to best interest outweighing privacy rights? When do you have to reference the Texas family code during a temporary orders hearing? I would encourage you to reference the the Texas family code as often as you can. Again, MRTs, if you go look at our temporary orders hearing sessions, I mentioned the Holly factors. The Holly factors, it's a case, the Holly factors come from a case, Holly v. Holly in Texas. Go look it up when you get a chance, and then you'll see what I'm talking about best interest. Fireflame, the attorney went after the mother's parents' income because she does not pay any bills. They wanted to use the non-custodial parents' income to support. I've never seen that happen. Usually if the parent does not have any income or do not have a job, they're placed on child support at minimum wage. Haven't seen a grandparent or even a spouse's income used for that. Yes, a person does, Malcolm, a person does have to be scared to pay up. Monique Jefferson, can the father recover money when they are frauded and that's not really his kid but gets a default judgment? The short answer is no. Not through the attorney general's office. Now, if they want to try to pursue something in civil court to sue mom, I haven't seen anyone successful at it yet. That's not to say that it can't happen based on the facts, but in terms of the attorney general receiving any money back, no. Malcolm, shout out the lead attorney. Yep, lead attorney is good. See, somebody in the audience knows about lead attorney. Oh man. Oh, you guys have a lot of questions. Let's see. You look young. Keep up the beauty regimen. Thank you so much. Um, how can someone in Dallas, Texas, find out a judge has ruled in the past cases? Peer reviews. Can we request a new judge? Ooh, this is a great question. So in Texas, there are. Let me pull up the site. In Dallas County, in particular, there is a certain thing called a judicial evaluation poll. If you all are in Dallas County or any county for that matter, you want to know about your judges, I highly recommend you try to go see what their peers are saying about them. I just dropped in the chat the judicial poll that just came out last Friday that talks about all the judges in Dallas County. Make sure you all pay attention to that. And as you remember or recall, I am running for judge in Dallas County. My opponent is Kim Cooks. I highly recommend you look up her judicial ratings. They were terrible. Know who your judges are, know who you're voting for, because all of these questions that you guys are asking me and you're talking about with judges not being fair and doing things they have no business doing, this is a way to kind of put you on game and give you some insight to that, because their peers such as me, we're telling you all what they are doing and what they're not doing. So great question, Ortiz. I put it in the chat for you. My brother and his baby mama recently broke up. The baby hasn't been born yet, and she seemed like she cares more about the money than the baby. How much would she get, and how does visitation work? It depends on what his income is, casual chase. It depends on an income. Child support is very simple. Now, in terms of visitation, the child will be under the age of 3, so it could be a certain schedule, a special schedule for him. But I encourage you to go review section 153 of the Texas Family Code that discusses children under 3. Um, Creator Mystery. I remember you came to the school. I'm guessing you talking about career day. Yes, I did. Let's see. Can a child collect child support if the non-custodial parent collects social security? Yes. If you go and read section 154 of the Texas Family Code, you will be able to see the benefits that are applicable to child support and those, well, net resources that are applicable and those that are not. How soon before a hearing is it necessary to submit pretrial pleadings? That is a great question. Because of COVID, with everything being virtual, in some counties, it's usually a day. It could be more than a day. What if the non-custodial parent continues to threat? Okay, sorry, y'all. My 2-year-old came in here. Video of that threat. My son's mother is working under the table. Hold on one second, you guys. Okay, I had to get someone to come get my daughter. All right. My son's mother is working under the table. How can I prove this? I am going to go over that because a lot of people hide their income. I'm going to specifically tell you how to do that at a later time. How can a non-custodial parent sign away their rights to avoid child support? They are a deadbeat. Fallon, this is an excellent question. Let me just tell you, in Texas, it is not easy to sign away your parental rights. It's not easy at all. There are a whole bunch of hoops you have to go through. So it's not simple as people would think it should be. How can I get an eviction from the pandemic off my record? I do not deal with evictions, so I wouldn't necessarily know. You may want to speak to an attorney that handles evictions in your jurisdiction. Every year he gets bonuses. Is there a way to get a piece of each of our for our son? He makes $35 an hour and gets $600 a month. There absolutely is a way. You can file a review with the Attorney General's office and request that an increase is made to the child support, but you need to show proof of this. Okay. Austin Self, I love you, Judge Vonda B. You are the most real. Thank you so much, Austin. And I love your name. My son's name is Austin. So I love your name. Thank you. Correa, thank you. Okay, let's see. This is quite informative and laid out excellently, Judge Vonda B. Great job, Vonda B. We are waiting for you to claim your seat in the 255th court. Thank you so much, Jonathan Hawkins. I appreciate it. Fireflame, when it comes to child support and the judge does not go by the chart on the Attorney General page, what should you do? Hire an attorney immediately. Do not try that on your own. Hire an attorney or at least speak to an who is this? You obviously came live to waste my time. Everybody else's time. Some good information here. Fallon, thank you so much for everything. You are very welcome. Mr. NyQuil, if the non-custodial parent receives VA disability, fully able to work but chooses not to, can that income be imputed? For purposes of us talking about the enforcement, I'm going to direct you to Section 154 of the Texas Family Code that talks about the different incomes that are able to be looked at for purposes of calculating the child support obligation. So I want to encourage you to look at those so I can get these last couple of questions in because we've already gone over time. Mother has been sole provider since birth of our child. No support is established. Mother has lost her job prior to hearing. Will that reflect badly on the mother? No, it will not. Why baby mama love money and they don't want to spend theirs? That's a great question. I have no idea. I may need to bring one of the guys on here one day so we can talk about that, and definitely bring on a mom to talk about some different things too that they're concerned about. We can do it. Are all Texas laws different? Great question, Fireflame. Texas law is Texas law. It all says the same thing. Now, are your judges applying that law differently? Absolutely. Some of them don't follow the law. I'm just going to keep it real with you all and tell you the truth. Some of them don't follow the law. They do not, for whatever reasons that they don't want to. They just don't do it. Is there a way to get child support when a parent has been deported? Excellent question. I don't know, Mr. or Mrs. Clark. I can't tell by the name, but yes, and we will cover that at a later time where we're talking about the modification. Let's see. Thank you again for your time. Happy Thanksgiving. Happy Thanksgiving to you too. That's all this hard work. It just sorry, Judge. We had an attorney. They said she could do what she wants. Some people, I mean, you can literally do what you want. Thank you. Love your show. If the moving party, okay, this is the last question. If the moving party is represented and the attorney is asking for their attorney's fees to be paid by respondent, what are the reasons respondent argue this? This is a great question, and I don't want to give you the answer yet because I don't want to spoil it. We are going to cover that in the enforcement series. Okay, so great session today, guys. Let's see. Nah, please answer my question. I'm really curious. I cannot answer your question. It is specific to New York law. I am only, limited to Texas law, so I cannot answer your question. I would highly recommend you speak to an attorney within your jurisdiction. All right. Let me see. All right. So we are going to wrap up for today. And the next time we will go live, let me look at my calendar just to make sure. Right date. All right. 30th. We're going to go live again at 12 o'clock p.m. Central Standard Time. All right. So Again, November 30th, 2021, 12 o'clock p.m. Central Standard Time. We will then talk about the possession and access. So the other parent has not been allowing me to see my child. I need to hold them in contempt. Make sure that you all are tuned in for that one, because the rules and what you need are slightly different from the child support motion. Okay. So make sure you all come to that one. You're ready to take some notes and get some information. Okay. I just want to also, while we're on here, for those of you who celebrate the Thanksgiving holiday, make sure you follow your court order, guys. You don't want to be threatened with having to potentially go to jail before Christmas or before New Year's. It's just not worth it. Follow your court order. If your court order says that the other parent is supposed to get the child on Thanksgiving, give them the child. Just do it. Same thing with the Christmas holiday coming up. Just do it. Follow your court order. Okay. Just stop violating the court order. Okay. Just make sure that you are following your court order to the T. All right. All right. And you all have a happy holiday, and I will see you on the 30th. Have a good one.